Lead paint disclosure in New York comes with 2 layers of legal obligation, and many landlords only know about one of them. Everyone knows about the Federal Residential Lead-Based Paint Hazard Reduction Act, requiring disclosure for all pre-1978 housing. But New York City adds a second, stricter layer through Local Law 1 of 2004, which requires landlords in buildings built before 1960 to annually inspect for peeling paint and window friction surfaces in units where a child under 6 lives or is expected to live, and remediate any hazards found. Violating Local Law 1 in New York City can result in HPD violations and significant liability. Our free New York lead paint disclosure form covers both federal and New York-specific requirements. It includes the landlord's disclosure of known lead-based paint and hazards, reference to any inspection records or test reports, the tenant's acknowledgement of the EPA pamphlet and their right to conduct a risk assessment, and, for NYC buildings, the Local Law 1 Annual Inquiry about Children Under 6. It's designed to satisfy both levels of legal obligation with a single signed document. Lead paint liability in New York has resulted in some of the largest landlord judgments in the state's history. Childhood lead poisoning cases that trace back to rental properties with documented lead disclosure failures don't just cost money, they cost landlords everything. A properly executed paint disclosure in your tenant file is your documented evidence that you fulfilled your obligations at lease inception and annually thereafter. Fill it out online, save your PDF, and include it with every lease for pre-1978 properties. Screen all new tenants at tenantscreeningbackgroundcheck.com to build a complete, documented record of every tenancy from screening through lease execution.